Good afternoon. Again, I am Richard Blake. I'm the Chief Judge of the Hoopla Valley Tribal Court. I'm the Chief Judge of Redding Rancheria and Tolowa Dene Nation Tribal Courts. It's my pleasure to be on this panel with two of my friends and colleagues, Jenny Walter and Olin Jones. I will let them give a little bio on themselves, as I could probably tell you, but better coming from their mouths.
Thank you, Your Honor. Again, my name is Olin Jones, and I am newly retired. I've been working for the past 18 years as the California Attorney General's Director of the Office of Native American Affairs. And I worked under four AGs during that 18 years, and I started law enforcement at the local level in 1973, so I think it's just about time to retire and do something else. So it's my pleasure to be here, and it's been an honor to work with these two folks for most of that 18 years.
Excellent. First, good afternoon. It's been a long day. It's wonderful to be here. I'm just thrilled to be here with Judge Blake and Mr. Jones. We've gone back quite a number of years struggling with the issue that you're going to hear about today. And what we're hoping is that our time together will be more interactive. The work that I did serving the Tribal Court State Court Forum in California is what brings me here today to share some of our experiences, some of our trials and tribulations along the way, and some of our successes. So without further ado and introductions, we're just going to get right to our presentation. But we really are hoping this is going to be interactive, so we're hoping to really learn from you where you've run into troubles and where you've found some success. So shall I start us off and then we'll... Sure. Okay. So we are going to... this is our agenda, and what we're going to do is talk about how the problem first was crystallized for the tribal court judges and the state court judges who came together about 7 years ago in California. And Judge Blake's going to tell a story of when he first contacted the California Chief Justice and said, we need to have a meeting. And that meeting is something that launched us in California towards really trying to solve recognition and enforcement of protection orders. So we're going to go very quickly through the context for us doing that and coming together, looking at some of the statistics that you're all very familiar with, and then some of the roadblocks we were encountering in California in terms of enforcement of tribal protection orders. And in hindsight, looking back at what we've done together, we realized that we really were quite strategic in how we solved the problem. And so what we wanted to do is share with you our strategies. Because when we came together, we said, we really have a call to action. And we have a call to action that we want to follow and then celebrate our success that enforcement is possible in California of protection orders. And so we're going to run through these themes of leadership, engaging community planning, implementing policies, and then institutionalizing those policies and practices, and then sharing protection orders across databases, whether they're court databases or law enforcement databases. And what we're hoping we can do with this agenda, if you're willing to share with us, is if we can, as we touch on these topics, that we can share with each other where is the leadership in your jurisdictions to make this happen? What kind of community actions have you been doing across your jurisdictions? So that at the end of this workshop, we're hoping to kind of have a sort of best practices of how we can get there together. So with that, I'm going to turn it over to Olin to go through kind of just sort of the context for this call to action.
Thank you. Have any of you ever had trouble with having a tribal court order enforced? Is that a problem anywhere else besides California? Okay. So this is the interactive part. Why is that a problem where you're from?
Well, am from Nevada. And so what I've just noticed in the last 2 years, I worked there. Prior to that, I was an attorney in Wyoming, also as a state criminal defender, and then a tribal court defender. In Wyoming, it's just politics and rednecks, and that's who sits in all of those positions within our counties. There's no tribal people anywhere in state government, and so it's just like they just don't pay attention and they really don't care. In Nevada, I think some of it is because they meaning the state has developed a family court system that they really believe in and really works, I think, for them, that tribes just aren't a part of. And so some of it is just sort of those border town issues with state police, state courts, municipalities not paying attention.
Sounds somewhat familiar. I think the problem in California was even more basic than that, and feel free to jump in. I'm going to start talking. Okay. But in California, when a state court issues a TRO, it goes from the court to the clerk, then it goes to a system in the state called CARPOS, which is an acronym for California Restraining and Protective Order System, CARPOS. We have, if I ever talk in alphabet soup, please let me know if you're not understanding what I'm saying. But when that order enters CARPOS, and a peace officer anywhere in the state of California is asked to enforce the order, he has to do a verification on the order, right? Is that true where you're from also? So if he does not get a confirmation or what we call a hit in the system on that order, he can't enforce it because he might be enforcing something that's outdated, no longer valid, and mistakenly violate somebody's civil rights by arresting or enforcing on them. But that's what happens when everything goes right, and that's on the state court side. That's usually pretty easy. But when a tribal court issues a DVTRO, they can't enter their orders into CARPOS for verification for enforcement in the field, because there's language in our penal code in California that states if you are not a public law enforcement or justice agency, you cannot put anything into the system. And tribal police, tribal courts are not public, are they? They're not units of local government or anything like that, so they don't fit that definition. So they would issue the order, but whenever it came time for that victim to show it to a police officer and say, I want to have this enforced, the officer would say, can't help you. And it would just go unaddressed. Am I right?
Right, and that was the little video we were going to show you. It's a 30-second spot, and it was happening over and over again in California because the tribal protection orders were not in the Department of Justice database. The law enforcement on the ground would simply say, we won't recognize it. And despite advocates, despite folks showing them, look, it's an order, there's the name of the judge, it's a valid, you don't need to. The law is very clear, full faith and credit. You don't have to be looking to see if it's registered or in any other database. So we were in this huge, like, sort of Sisyphean battle with trying to convince law enforcement statewide that they needed to follow the law.
You have a question, Jim?
Yeah.
My name is Mary Ann Mills, and I'm a judge for the Kanaitse Indian tribe. And we had the same problem at the beginning of getting our court orders for the police protection, or, you know, to have them followed. So what we did is we filed a foreign order, and it was accepted. And after that, the state started to work with tribal court codes.
So that was the first stop on the road that we took together, was registering them as a foreign order. And so you'll see in your handout, that was one of the workarounds we tried to implement. Because after all, time was ticking by, victims were not getting their orders met, and we were like, let's get pragmatic. And it was a tough decision, right? Among the tribal court and state court judges, that conversation was a very difficult one, because why should a tribal court go through and register their order as a foreign order? That isn't the law.
So look, I want to tell my story a little bit. It's probably the time. So I sit as a tribal judge in Hoopaw, California. Hoopaw is very, very remote. And when I say remote, we, you know, in order to, I like to give it by landmarks. We are to the closest McDonald's at 61 miles, to the closest Walmart we're 73 miles. So, you know, you have to, unfortunately, that's how you have to gauge in my area how close you are to things. So, yeah, state court, I mean, it's still about 69 miles, I think, to the state court, and you have to go over some mountain passes, and it's a pretty cumbersome process to get out there. And with transportation issues in my community, that is almost impossible. So members in my community are coming to my court. They're filing their orders of protection for domestic violence cases, and I would issue these orders. So about my second year on the bench, I was at my house one night. It was about midnight, following a full day of hearings. I hear a knock at my door. Who's at my door at midnight? So pull open the curtain, and I look, and there stands this lady that was in my court earlier that day. She was bloodied and had been assaulted. I opened the door, and I looked at her. I said, "How can I help you?" And she said, "They're not enforcing your court order." I said, "What do you mean?" She said, "The sheriff's department will not enforce your order because they said it's not a valid order." I said, "Excuse me?" She goes, "No, they told me it's not a valid order." I said, who told you this?" "The deputy sheriff." I said, "All right." So unfortunately, there was nothing I could do that night. Talk about having your hands tied in your own community, having a victim standing in front of you. So what I did was, the next day, I contacted the sheriff's department, and I said, "What is going on here?" And they told us, "Well, you know, we don't have no way to verify that, you know, these are valid orders." I live in a community where the deputy sheriff, the sheriff's department at that point was connected in my court. We rented space to them, so they were right there. They were able to come over, knock on my door, and say, or even just walk right in, because they bailiffed my court. They did all kinds of things, so the relationship was there. So at that point, I thought, you know what, this is not good enough, because members of my community are not safe. I'm writing an order that is not being given full faith and credit by the state court, by law enforcement. So what I did is, at that point, I kept thinking to myself, how am I going to do this? My brain says, you gotta be big. You gotta go big on this. So I wrote a letter to the Chief Justice, then Ron George. I said, you know, "Dear Chief Justice Ron George, I want to have a meeting with you, or with the chief judges in the state of California from tribes." And we waited. Never heard anything for, you know, it's 3 or 4 months later. One day in the mail comes a letter from Chief Justice Ron George, who said, "Yes, we are going to meet with you. We're very happy to do this. We're going to meet with you. And what we're going to do is we're even going to pay for it. You guys all come. We're prepared to listen." We went to one of the most impressive buildings in San Francisco, the Judicial Council. We met with the Chief Justice and the Judicial Council on this issue of this protection order. Out of that first meeting stemmed many, many more meetings. Many more meetings that helped develop the California Tribal State Forum. Jenny talked about some of the fixes. The fixes were, like Marianne and like Judge Mills is talking about, is a registration of foreign judgment. Okay, well, that's a good fix, but what happens on a Thursday afternoon and Friday is a mandatory holiday, or a mandatory, what they call it, furlough day for the state court because of budgets. So then my order sits there Friday, Saturday, Sunday, Monday, if it gets to the judge on Monday because of calendar. And so on Tuesday, they may get to that order and say, okay, well, yeah, we're going to sign it and send it back out to us by fax. And so the victim all weekend sits with no order, and then in a sense has no order of protection that is going to be recognized. So another fix was we were going to do a DV 600, which is a form that is used in California. DV 600 is documentation that says, it gives the identifiers, it's attached, and it's registered with the foreign judgment. Then the state court would forward that information on from the state court to the sheriff's department, who would enter that into the system, and it was going into a system that we will discuss later. But not for that incident occurring, this would probably still be an occurring circumstance in the state of California.
So let's see, let me just skip ahead here. I do want to take just one moment, because when we talk about domestic violence in Indian country, we often don't address the fact that it cuts across both genders. And there's a recent study, and we wanted to highlight that for you, that the information has been out there. This is the little video we were going to show you. It's Judge Christine Williams acting in a 30-second spot. If you've met Judge Williams here at the conference, and she's holding a protection order. And in 30 seconds, we kind of encapsulate what the problem was. And so there's somebody on the street trying to break the order, and somebody trying to get it enforced. And we really took that little 30-second video, and this is where I said we were kind of strategic about how did we want to make this problem understandable to everyone so that we could fix it. So we did that, and then we said we were going to take the meeting that Judge Blake initiated with the California Chief Justice, and we're going to invite all of the tribal court judges in the state. There are 23 tribal courts serving about 40 tribes in California, and about 110 federally recognized tribes in California. So we were, thanks to Judge Blake and his writing the letter on behalf of the Northern California Tribal Courts Coalition, we had that meeting and was launched the type of leadership that could happen, that can only happen really with judges like yourselves, where you have tribal court judges and state court judges coming to the table and saying, look, we've got a problem. We've got to fix it, and we've got to figure out how to fix it fast. So they came up with the pragmatic solutions that were described, the registration of the order, and they came up with, well, since the courts on the state side can control a database of protection orders, we'll make sure that tribal court protection orders are at least in that database, so that the tribal court judges and state court judges can view each other's orders. But it wasn't just the judges. And I think that it's really, this is something that we were talking about as we were preparing for this. Leadership came from the community. It came from advocates. It came from tribal governments. It came from the feds, and we'll tell you a little bit more about their role, because their role was really critical in really the solution that we reached. And it came from prosecutors, and it came from law enforcement, maybe sometimes kicking and screaming, but it came from law enforcement to solve this problem. So here we give a kind of a plea to those jurisdictions that don't have forums to consider launching them. And just a show of hands in your jurisdictions, do you have a tribal court, state court forum? Great. Michigan. Yeah. So if you need help forming one of those, your colleagues right there who are raising their hands, those are the ones to reach out to. Judge Blake, he's the one to reach out to do that. All right. So, a word about the forum, or do you want to?
Sure. Skip ahead. Let's real quickly. So the development of the Tribal State Forum, when it was developed, the Chief Justice adopted the concept that we're going to have this forum. And what he asked me was, your idea, I want you to co-chair that. And so what he did was he appointed me to the commission forum, and then he also appointed a co-chair that was it was always a appellate justice that sat with me, and initially we went through quite a few. We went through a couple, and but I'll tell you, every one of them was unique in that they had something to offer to advance the forum. It was always a positive relationship, and out of the tribal state forum, the federal court system started saying, "Hey, wait, we want to bite at this apple too." So the tribal federal forum also included two tribal court judges in their forum, and again, that is something that is led by the Chief Justice, and one that I currently still sit on is the tribal federal forum. After several years on the California the tribe state forum, it was time to step back and let somebody else run that. It was time to step back and let somebody else with a new vision take that over. And currently, Abby Abinati is the current co-chair of the California Forum. And quite honestly, I left it in great hands. I still active with the forum, and Jenny and I, in the development of all this, we stand back and smile now because you know what, we get to look at the fruit of our labors there. It's been a phenomenal journey, and one that I will continue to follow. The learning from one another, I'll tell you, there's nothing more that we learned from one another than how each one of us has navigated the obstacles that we had with our individual counties, with our individual judges, and with our individual states. The fostering relationships, I was appointed to the California Blue Ribbon Commission, and that's where I got access to the Chief Justice. I met the man, and one of the things that I continued to talk about was this Teague protocol that they had and I was a firm believer in it. And so I continued that, and when this opportunity came up to talk about the development of, to talk about the issue of enforcement of protection orders, it gave me the ability for the Chief Justice, one, to know who I was, and me to have the ability to have access to him. But don't let that be an obstacle, because you know what, you can write a letter to any Chief Justice and they should respond. The identifying issues of common concern, my gosh, I was amazed when we got into dialogue with the state, how many issues they had that were similar to us. They had as many questions about us as we did about them and our processes and how we were going to work those out. And the addressing these issues through the collaboration, problem solving, and mutual respect, you know, that speaks volumes, because what we found out was it was okay to agree to disagree, because not everybody, when you're working with 23 sovereign nations or whatever the court systems is, right at this point, you're understanding that the state has to adapt to these different rules, and if they're different, then you're developing a relationship with each one of them in the state of California. It's not just one size fits all. It was, there were several tribes there that they had to work with.
So I think we're going to pass it to Owen for the. So leadership was really one theme. The second theme that both the Department of Justice and the forum engaged in was a lot of listening. And I'm going to turn it over to Owen for the regional meetings, and then I'll talk about the statewide. Yeah.
Well, how many of you know that if you work for a state agency and you're Native American, it can really be a tough position to be in, right? I don't have to really repeat that too much, because I think you can imagine, because you're a sovereign nation. As a tribe, the state is sovereign. So, and the sovereigns exist in the same political, economical, legal environment. There's going to be some friction. But when you're a member of a sovereign nation and you work for another one, it's a little bit uncomfortable for me. So when the tribal folks, Jenny and some of the folks from the coalition, began coming to me with this problem, they came to me because in California, that CARPOS database is part of a bigger database that's called CLETS. And, the California Criminal History Information System is huge. It's got motor vehicle information, gang data, medical information. It's huge. And we administer that, or my old agency administers that system. The Attorney General's office is over the agency called the Department of Justice, and they administer that system. So tribal folks began coming to me and asking me, well, why can't those orders just be recognized? Why can't we just have what we need, because it's a public safety issue right now? And I agreed, but as I told you before, it's in statute, and access into that system, to put anything into that system, means you have to have access. And access into that system is closely guarded by the state of California. So we, or my old agency, might administer that system, but we don't have any discretionary authority over who has access, unless, if they're out of code, you just can't get into it. And I think that full court press was on with me because I was the chief executive for Native Contacts in California on this issue. So that went on for about, I want to say 10 years, right? No, was it? It was quite a while. Yeah, before the forum. Yeah, before the forum. So it was quite the issue. And the only way I could think to solve it was to get everybody who I thought might be a stakeholder together in one room and have some meetings about this. So we had some smaller meetings around the state to talk about it. And I could never really get the Sheriff's Association, District Attorneys Association, federal people. I could never get all these folks together at one time in one room to really have a good overall discussion about it. So I think, Jenny, it was March of 2016 when we had a meeting, right?
It was the big statewide meeting.
Right.
Yeah, you're skipping ahead a little bit, but go for it.
Okay, all right. I'm trying to cut through some of the. So, anyway, we did have a big meeting, and some of the solutions that we talked about for this problem involved things like legislation, and I don't think that was a very good solution, because they wanted to go in and do a legislative process, and there was no guarantee what that would look like when we got through with it. So folks decided not a good idea, and there was a workaround in place. You want to talk about the workaround for a second, or?
Yeah, I think we talked about the two workarounds. That was the registration that we talked about. There were two, and then the state courts had their own database. So the tribal court orders could be put into that database for verification.
Right.
So you want to?
Okay. And that was okay, but it wasn't quite satisfactory at all. And so at that meeting, there was a rep from the Office of Tribal Justice in D.C., and Marcia Good was her name. And she was very clear that you folks in California, by not honoring or letting those orders into the system, not letting them be enforced that way, you are in violation of federal law. And we are prepared to take action against you if you do not do that. So that was what we had to deal with. And after we talked and had several more meetings, several people came up with an idea, and I think that the idea is in your handouts. And it's something called a law enforcement bulletin. And the California Attorney General's office has the ability to issue a law enforcement bulletin, and I'm going to give you just a second to find that and take a peek at it. And I really have to give, yes, sir. I have to give Kamala Harris a lot of credit for taking a stand on this, because she had to tell the sheriffs and the DAs in the state, this is what we want to do. We want you to enforce it, and I'm using my authority to make that happen. But we did have a lot of meetings in between, and we told the sheriffs what we wanted to do, and they did agree that this would work. And I think Greg Thompson is here. Greg, you were part of that discussion as well. So it was a huge problem all over the state. And I have to tell you, before we came up with this very good solution, I had tribal DV advocates coming to my office. At some point, they would even bring victims with them to show me what was going on. So I was really under pressure to move this solution along in-house within DOJ. And when you bring people together to collaborate like we did, I think you have to, if you're going to be that person that's going to bring people together, I think you need to know their temperament, how far you can go, and you have to know that, like, the leaders in the state, like the Sheriff's Association, district attorneys, you have to know, like I had to know the Attorney General's, probably her limit for how far I could push this issue. But we had to demonstrate, and the forum was a huge part of that, just how very important this issue was to protecting Native American communities, because up to this time, a lot of those orders weren't being enforced. And it was a horrible situation for people. And when you're the chief law enforcement officer in the state, it's really, really wrong to not address those types of issues. So I think I jumped ahead quite a bit.
That's okay.
Is that all right?
So no, that's good. So that was the solution, which it seems like a no-brainer. The law is clear, and now the DOJ says the law is clear and writes it in a information bulletin. But let me just give you a little bit of background on, it didn't just happen because of judges and DOJ and folks running behind the scenes trying to get a piece of paper from the Attorney General. And I think that's the important piece that I think we want to also bring to bear on this, is that there was tremendous community engagement. There was, just the way Olin describes the fire on him to respond, advocates came out and said, we want to tell our story. We need to be able to garner those stories and pull them together. So there was a statewide needs assessment, and we had about 8 months at the state to come up with a plan where outsiders, non-natives, would be able to work in tribal communities to get a statewide needs assessment accomplished. Well, I'm looking at Jerry Gardner in the back because the brilliant move that the state made was, we're going to contact every tribal government in California, identify the problem, say we're in it with you, and can you please identify a tribal consultant that you would want hired to basically do listening sessions or focus groups within your community. And that was a year-long process of, and all of the tribal governments picked the first 2 tribal organizations that were picked. They could get their first choice. And so those were the individuals and groups that went in and worked in tribal communities to bring forth their stories. And really without that kind of advocacy at the local level, together with judges, together with everyone saying that we need to change this, it wouldn't have changed. So I just wanted to really emphasize the role of community engagement in this, that you can sit in a state agency, you can sit in your tribal court, but without that true getting out there and having those relationships, it just doesn't happen. So I'll have to pass that on.
So I retired full-time August 10th, and up until I retired, I haven't heard of any enforcement orders that were not enforced. So I don't know if anything bad has happened. I didn't hear about it, so I'm presuming that it's working. But information in the law enforcement community has a short shelf life, and this is something that has to be refreshed all the time. You have to continually go about refreshing information. It's like training on PL 280. You have to continually do it because of retirements, shift changes, or whatever. So we want to keep the effort going, and I think that Jenny and I are hopefully going to be able to do some training on this issue for the law enforcement community in the months to come.
So the other thing that folks were able to do, and maybe Judge Blake can address this, is that is the policies that were put in place. So one was what Olin described, which is that piece of paper, the information bulletin. But the other is there are these ways of codifying things. And I know other jurisdictions have done similar things, so we wanted to point that out and ask you all what you've done. So we'll turn over to Judge Blake.
So looking at the policies that are listed up here, what we decided that in order to get enforcement of our protection orders, we needed to not only come together and agree and codify what the agency was going to do as far as full faith and credit. You know, Olin was correct. I mean, there have been a lot of fixes, and they are not as frequent as they used to be. Do they still exist? I'm certain they do, but do they rise to the level that they were when I had my issue with somebody knocking on my door? Probably not. But the issues that that have happened is we're starting to see models across the country that here in Indian country we're finding when you're finding something that works, don't refix it. It doesn't need to be refixed. Use it. Run with it. I'm a firm believer. I'll tell you, if I see something out here I like, I'm going to go back to California and I'm going to tell everybody I thought of it, and I don't care whose idea it was. It's mine. So, but one of the things that when Olin was talking about the AG, one of the things that the AG is now a senator, and the NAICJA organization did our days on the Hill, and we went back and we met with the senator, and she continues to support Indian country. So not only as AG, the chief law enforcement officer in the state of California, but now as a senator, she finds out how important it is to continue to support this issue even beyond the AG position. So that in itself was I think a real development for Indian country in the state of California. The one thing that I think that we had an issue with was the reinforcement of protection orders between jurisdictions, meaning that our law enforcement officers may see a protection order, they'll say, well, that doesn't look like a tribal court order, so I don't know if we should be reinforcing that. No, you're going to enforce that. You are going to enforce that order. And they will call and say, well, look at this order, Judge. Do you think that that is not for me to determine? That is an order for you to enforce. I am not going to interpret that for you. That is a domestic violence protection order that is issued by a jurisdiction that is not mine. I am not going to get into that battle to try to determine whether or not it is valid. You enforce it, and then we worry about that. One of the things that they always talked about was liability above and beyond if they were to enforce an order, and I think we've talked about this before, is a liability if an officer is to enforce an order, and what liability there is on the officer, and if they were to enforce an order that was no longer valid. And the safety protocols for Native victims in Indian country, we have worked very hard on developing those safety protocols, not only with domestic violence shelters, but court to court, agency to agency, and we're finding that those are creating safety nets for our victims in Indian country.
And then another note on training. I'm looking and seeing somebody in the audience who can also speak to this. A lot of what we did was work with training materials for law enforcement. So the State Judicial Council, together with law enforcement, and Judge Tomczyk is here and can kind of talk a little bit about that and share. we said, you know, it's going to have to be that we're going to develop tools together, and they're going to have to be spread out through statewide. And it's still, as Olin said, still an ongoing education process. But we developed probably a good 10 tools that law enforcement can use that are like frequently asked questions, addressing the immunity stuff, so that they can respond to it. I don't know if you want to say a couple of words about that.
Well, first of all, kudos to both Jenny, to you, and to Olin for making this happen. At the time, I was with the Sheriff's Department in working in tribal issues, and we have 18 federally recognized tribes, have a great relationship, we're pushing, but there's tremendous resistance, quite frankly, in most of the other counties to doing something. So if somebody simply is across the county line, and which is easy to do, whether you're in Orange County or Riverside or wherever, we're not getting the same kind of support. But with these tools now, what it's enabled is to have consistent training of sheriff's deputies and police officers statewide. And it doesn't necessarily have to be a how-to. It just has to be, there's a check mark in their brain that this is something that, there's an answer to this question, and it's not necessarily, no, I don't recognize this piece of paper. Because if you think of law enforcement training, you know, and they're doing everything from search and seizure and how to use their weapons. I mean, there's a catalog for them to learn, and this can be depending on the jurisdiction, either a large or small piece. In San Diego County, we instituted mandatory training for every deputy sheriff on this subject, on the enforcement of the law in Indian country and in dealing with protective orders. But not every county is going to have that luxury. So it's just these kind of creating the signpost, that sort of check mark, which I think is extremely effective. And you're gonna have to reach people. I mean, as we speak, people are retiring from law enforcement, and somebody new is taking their place. So you're always going to be missing, the newest cop on the beat. But with these tools, you're reducing the risk that something's going to fall through the cracks, which is really all we can do.
So what some of the tribal courts are doing is they're taking that DOJ order and putting it on the back of their tribal protection order, so that, Joyce, you have
So what do you do when law enforcement themselves don't enforce the law?
So when they're looking at the law,
In your county, Olin, you know the problems we have in your county. So what do you do when your tribal police officer gets arrested by local law enforcement for enforcing a TP 600, a domestic violence restraining order that they've honored previously and arrested this person, but all of a sudden on Christmas Eve don't want to arrest this person, and then the tribal police officer gets arrested on New Year's?
Maybe just a quick response. I mean, you've got problems. I mean, seriously, on this, putting together this, Inyo had a representative, and they pulled out of the committee working on this because they didn't support it.
they hired somebody to litigate that case that's up, that just got remanded to the district court.
Yeah,
So, yeah, I mean, it is a unusually.
Now we have no tribal police because nobody wants to go.
So one of the issues that we even had in Hoopaw was your deputization agreements is only as good as a sheriff that you have in office. And we sat for, at one point there was a disagreement with our sheriff in Humboldt County, and so what they did is one day they said, yeah, we don't like this anymore, so we're going to pull our cross deputization agreement. Our officers actually had no arrest powers whatsoever. And then what he turned around and said, if I see you in a vehicle that is marked as a law enforcement vehicle, I'm going to arrest your officers. Nothing creates, public safety issues than when you have two agencies that are going to fight over, over that. our cross-deputization agreements have, I mean, at best, I mean, when they brought it in, they said, Judge, we want you to look at this. I mean, my mouth was bloody from looking at this cross-deputization agreement because it was very, very poor. I have a council member from the Hoopa Valley Tribe sitting here, and and I have no heartache saying that it was so poor that I think that you're putting our community at risk by even agreeing to this. And we have our sheriff has retired, and his undersheriff has taken over. And I think that we're going to run into this because now our officers are trying to become select officers, and there's going to be an ongoing battle with, instead of collaborating and finding understanding that we are all about safety, trying to find a common ground where we're doing what is in the best interest of the community. No, it's all about let's flex a muscle and see who can arrest who and who can do what. It's wrong, and that's the basis behind the forum in California was. I'm not fighting with the state for cases, and I don't think my colleagues in California are either. But what it is that let's find some place where we're going to be able to say we're issuing a protection order. We would like you to enforce that protection order, and likewise, if you're coming back, we have to send it to you for a foreign judgment. I'll do that if that's going to ensure my community.
We've been doing that since 2005. In fact, it was the state judge staff who worked with us and said, let's do a DB 600 on every tribal order so that it will be automatically entered into the system, which it supposedly was. And the state judge was fantastic when we started. He came out, he wanted to help us get going, but it was law enforcement that picks and chooses which ones they want to enforce. We're telling tribal people they have invalid restraining orders. And then the sheriff was saying, well, let me know what that officer's name is so I can investigate it. But when they refuse to give you their name over the phone, it's like, what do you do?
Exactly. Well, one of the things that we had is, in my community, I know those guys. Like I said, they're my bailiffs. I know them. So, the officers, and I always tell, give them a bad time. One of the things I tell them, I hope that's not your family member that has a protection order, because you know what, if your family member is coming and beating on my door, I'm certain that you're going to be standing behind them asking me why my order was not enforced. And to give that same question to the sheriff, asking the sheriff, why is it that if Judge Wilson or Judge Heinrich from the Superior Court drafted an order that that your officers are going to go out there and enforce it, but yet me as a tribal judge, elected like your state court judges, the same education as your state court judges, all these things, that you're going to tell me my order is not as good? No, that's not acceptable to me. One of the big concerns that I have is, have we had a fatality because of a failed protection order? Certainly we have. We certainly have. So,
what would his explanation been as to why it's not as good as the state? I mean, what was their beef, and what was their suggestion to make it right?
One of the things that the officer told me was, it doesn't pass the squint test. And I was like, squint test? And he goes, I'm going to squint, and if it looks like what I'm used to enforcing in a field on a state court order, I'll enforce it, regardless of whose name's down there, because our order did look a little different. So then we tried to adapt that. We tried to adapt that to where, with the help of the Judicial Council, with them unlocking their forms so that we could put county of or tribe, in the header, so that we were, that way the officer on the street, when they were seeing these orders, would say, okay, I recognize the order. It's not the same, exactly the same format, but again, that squint test. The squint test, it was just a way to say, yeah, I just don't want to do that.
If that's your guy on the street, how about further up the chain of command and law enforcement? They couldn't have possibly said that with a straight face, or could they?
Oh, they can. They do.
Yeah, so they have bent over backwards and done crazy things to try and get full faith and credit to happen in California. We've described these workaround solutions. We've described DOJ saying, the Attorney General saying, follow the law, here's this information bulletin. And there are still jurisdictions, I think far and few between, but Ms. Joyce Alvey over there is definitely in a jurisdiction where there is litigation right now. And honestly, the sheriff's office issued a cease and desist order to the tribe, basically saying you don't have tribal authority as a police department. So when you're at that level of discounting your counterparts, you are in a very untenable situation. I don't think there's anything any three of us can say to fix that until the litigation.
We did have the monthly, we had monthly meetings.
You were the poster child.
Right.
We had terrific relations.
The district attorney, the
Everyone.
probation, we met once a month.
Yeah.
Everything was fine, beautiful, we're all working together until all of a sudden this just happened.
Yeah.
So we haven't met since 2015. And the case was just resolved a couple of months ago. And in fact, in September, we had our first meeting again where everybody's back at the table. Now, what's going to happen? I mean, there's a lot of trust issues going on there. But hopefully we'll be able to start working together. We did have this letter, to show to everyone, but of course they didn't want to see it because they had already seen it. So.
Well, another issue that we had is we went to Olin's office on a visit to try. Jenny, Dennis Perlis, and I think Abby went with us at one point to meet with the AG and to talk about we had a meeting, and the California Sheriff's Association sent their president, and you talk about the naysayer. There was a naysayer in the room. It's just like he just crossed his arms. I mean, you could just see the disdain on his face, and it was like, "But yeah, okay, yeah, well, after that meeting." But there's nothing more discouraging than walking out of a meeting and thinking, "Okay, bite your tongue so you don't say something that's going to ruin these collaboratives that you're trying to develop." And in any country, come on, we all know that feeling when you're doing all the giving, and sometimes you have to take the kicks in the back to be able to continue these relationships. But as Jenny said, they do work out. Sometimes.
It'd be a great time to show that video.
Yeah, it would be really good.
It would be a great yeah.
So it's a culmination of trying to sort of both to push out the information to all law enforcement. The incoming Attorney General did an introduction to an education piece. It's a short video we were going to show you, which has Judge Abby Abenanti in it, Kate Keneally from the Department of Justice, describing basically follow the law. But it's an educational video, and then it ends with the president of the Sheriff's Association also saying, this is really important, everyone, follow the law, and here are some resources. Go here for the resources that Judge Tomczyk referenced and other resources. So the goal was to try and push it out to every law enforcement agency and to put the message in the messenger that would be able to get the message across, law enforcement to law enforcement.
And to defend that statement that I made earlier, I hadn't seen the video. I had not seen the video until an event, and after I saw the video and did see the change of position, it did make a significant change in my opinion about the California Sheriff's Association at that point, because then it appeared that they were receptive to working with us. Except in Inyo County, yeah. I can't help you in Inyo County.
So I can't begin to tell you the contentiousness around this whole issue, and I think the responsibility for trying to move it along fell on Jenny and Coalition, myself, and some folks from the Sheriff's Association. But it did turn out, and this collaboration really worked. But I can tell you this, collaboration is a lot more than just meeting. We had to have some really tough discussions in this process. And it's those kind of discussions that can only be equal to the things you say to your family. Like if you ever have to tell You ever tell your mom you're going to put her in a nursing home? I mean, that's a really horrible discussion to have with your mom. But that's the only thing I can liken our discussions on this whole issue, because it was really very contentious. And it came down to building relationships and working with people and figuring out, and I know this may seem like it's dramatic to you guys, but this was a big issue in California. And I'd like to think that those relationships that we built through this process are still there, and they're still very solid. So, and we're gonna, well, somebody, whoever has my job in the future at the AG's office, is probably gonna have to broach the issue of directly accessing those orders instead of just looking at them and knowing you're obeying federal law, but I still think they should be in the system and be verified through California's criminal history information system. So that's probably on the forefront. We won't be there to fight that.
Oh, come on. You said you're retired. Stop. Yeah.
But I do think that's the next best step, is to make sure, because I think even though this bulletin is out there, there's probably still room for some error.
So the next slide you see is a collaboration between sovereigns. A collaboration between sovereigns definitely could mean between the tribes and the state, but it could also mean tribe to tribe. And one of the things that we found out is working with the tribes. And I also had another vision. My vision was the development of the Northern California Tribal Coalition. The coalition was because we had so many tribes in my community. I thought, you know what, let's get together and let's get these court systems together, because we had a lot of intermingling. I'm of Hoopa, Yurok, and Karuk descent. So I mean, I have family that lives at my dad's registered Yurok. My cousin Diane that sits on the council, she also is of Hoopa, Yurok, and Karuk. I mean, and so when you're talking about working with another nation, the collaboratives. I recently had a case on on a case where tribal members from from Yurok they filed a case in my court, but one of the parties wanted to go back to the Yurok court because they were Yurok tribal members, even though they had no jurisdiction because the action occurred within the Hoopa Valley Indian Reservation, and I tried to explain it to them. And so bench to bench, I reached out to Abby and said, "This is what we got going on." She goes, "Your party, you have fun. We're not gonna fight over this." Excellent point. But you know what? The collaboratives have allowed for improved public safety. That's the big, folks, that's a big issue. That's what it's all about. It's about making certain that community is safe, that these orders are protected, that these individuals are receiving the benefit of a valid protection order, and that no matter what law enforcement officer is looking at that, whether it is tribe, state, or even federal, that they're looking at that and they're seeing that there is a order of protection, and that they enforce it and give it full faith and credit that it is duly afforded. The restoration and healing, they mean improved chances of restoration and healing. You know, we are now at a point where the NAICJA organization is looking at the ability to work with domestic violence victims in some form of restorative justice matters. And we, as we broach that subject, because sometimes it can work and sometimes it can't, but ultimately, as a bottom bullet there indicates, it's about the outcomes. It's about the outcomes for our membership, and making certain that everybody is afforded the same ability to enter into a court system and understand that your court system is going to do the very best, that relationship with a state agency or county agency is there, and that we are doing everything in our power to do so. The collaboratives, I'll say in the state of California, if it can happen in California, it's going to be able to happen anywhere. Because the state of California, did we have obstacles? Yeah. Were they easy to navigate? sometimes, yeah, sometimes I would say. But you know what? It took the Olin Joneses, it took the Jenny Walters, it took the Judge Thompsons, it took all these people to be able to come together and look and see that there was a common thread, a common theme that we had to address, that we had to continue to dialogue about, and understanding that sometimes they weren't solved overnight, sometimes they're ongoing. But to be able to sit down, roll your sleeves up, and continue to dialogue on these, and understanding that, you know, nothing was created overnight. And our program, I mean, our Tribal State Forum continues to hammer at these issues so that we're able to afford members in our community, and with the cooperation of even the current Chief Justice in the state of California, phenomenal friend. I don't even say colleague, I say friend, because the woman eludes 100% support for tribes. And you know, that development between the Chief Justice of the state of California and the court systems, the tribal court systems in California, speaks volumes.
So we did promise interaction, and I feel like we've been all talking. So I just want to touch base with all of you. So when you think about our challenges in California, and obviously we have yet a long road ahead of us in jurisdictions where it's still tribal protection orders are not being enforced. Can I ask if there are, if this has sparked any thoughts about some leadership actions that have taken place in your jurisdictions, or ongoing education that the bench is doing with law enforcement, or anything like that? Is that so that we can also learn from you? Because you can see that we still have challenges in Inyo County. I can also say that a large part of what helped us in California move law enforcement was the role of the U.S. Attorney General was really critical, and having conversations with some of the deputies there and saying, could you please influence folks that perhaps a lawsuit might be filed. Perhaps California might go the way of Alaska if we don't get our act together here in California. So I would just say it never hurts to call in hammers when you can, if folks are having trouble getting to the table. So as much as we're talking about collaborating and hard work, I want to emphasize that outside pressure that can be really critical. So then I want to turn to, we also want to not leave you without some resources. So the Tribal Law and Policy Institute, which is the organization that's responsible for this workshop and are coming together and doing this, has really a terrific resources. And you know, you probably met Marlon and Heather out at their table and their booth, really wonderful resources there to share in terms of developing a tribal court, state court forum. They have a whole Walking on Common Ground website with resources. So, you know, please, you know, use those, as well as obviously reach out to your colleagues. And then we just wanted to also indicate, you know, some resources that you already probably are familiar with, and wanted to point out that Sarah Deere has a new publication out, which is really wonderful, and we commend you to read that.
And one of the things that when the prior TLPI, I will tell you that if you call TLPI and you ask them about a topic, and if they don't know, I guarantee you Jerry Gardner's going to find it for you. He'll find it for you, and he'll forward that information on to you. They are that committed to making certain that they're providing the best technical support that they can. I would encourage you to reach out to them.
Just another comment on that. When Washington State was, and you'll remember this, Richard, when Washington State was putting together their consortium, we came to California, met with you, but that was orchestrated by TLPI. Right. So, and their Walking on Common Ground program. So, and it was great for us to come down and get to meet with all of you and get copies and so forth. So I would encourage that for anybody.
And the state of Washington had a very robust. They were really pushing, and they had a very innovative state court judge, and I think unfortunately she has passed. And but again, that was, and the NAICJA organization, we do collaborate with TLPI, and we have another event in the month of December that that we are partnering with TLPI on, and I can't emphasize enough the importance of the reaching out to them with questions, or reaching out to the NAICJA organization, or as Jenny will show, any of the three of us. I mean, we would be more than willing to help you out with any questions that you may have, and how we've done what we have in the state of California.
You know, one more thing, I think we spoke to another I just wanted to mention, one of the things that drove me a little bit wild is when I would look at our system at Cal DOJ, and I could see enforcement, or I could see TROs from other states that were properly registered in our system. So they would come from South Dakota, North Dakota, Minnesota, Arizona, New Mexico. There they are. But the ones from California, and that was just a little bit crazy making for me. And I have to, I don't know why that is, but.
Sure.
You have a question?
Yeah, I have a question. I was wondering how long these protection orders stay in the registry. If they expire, are they purged, or are they in there?
That's a good segue to the question that Judge Blake just asked me to address. So, so there are two databases, just to be clear. One that's housed with the Department of Justice, and one that's housed by the state courts. The state court one is the one that allows a tribal court judge and a state court judge to view each other's orders. They're scanned into the system. So they're really quite valuable, because you can really read them. If you're not in law enforcement, that you might not be able to read those that are in the Department of Justice. Those are never purged. So those exist for as long as the orders exist, and then they're taken off when they're not. I didn't say that right, but technically they come out of the registry when the date expires on the order. In terms of the Department of Justice registry,
They stay until the local sheriffs. They're in charge of the node at the county level, so they're the ones who modify those orders or delete them.
and it's actually there. Some of the courts some of the state courts have the node and enter it, and some of the law enforcement agencies enter it. So it would be dependent on who did the entry.
Right. You can tell this gets really deep at some point, but we didn't intend to get too far down on the weeds on the nodes and the local. I didn't even mention hot files, Greg. I didn't even go there.
There's another question.
Yes.
So do you register them also with NCIC?
Yes.
They flow from the state database into.
In fact, I think that's probably how those out-of-state orders got into our system. Probably. Yeah. So, good point.
Did you all have any concerns about sharing that information with the state or federal government?
The only problem that the only thing that we did, there was concerns that we were providing data on membership that could create problems. But you know, one of the things that we found is that, as I explained to you, I'm of 3 different tribes, and kind of a transient. I mean, some of these people are very, very transient, and you know, if there's an order in Hoopa, they may run to Yurok, or they may run to Karuk, or they may run to Redding, they may run to all these different places, and the filing of these in the state system allowed an officer in another jurisdiction to be able to see that order, and it was beneficial because we have a lot of people that may do an assault in Hoopa and will run to another jurisdiction to hide, and ultimately the victim may end up there again and be assaulted yet again, and so it did provide the ability for the local law enforcement agency to be able to see that there was a prior order. And I think there is even a case about a prior a conviction in a tribal court for domestic violence being used in a state court hearing, and whether that was constituted a prior conviction for domestic violence, and it was found that it was. So we enter everything that we get into the state one that filters into Olin's system, or Olin's former system. All righty, folks, thank you very much.